One sentence can decide whether a person walks free or spends years behind bars. Police officers use it every day. Prosecutors rely on it. Judges analyze it carefully. Yet most Americans don't truly understand it. That sentence is, "We had probable cause." What does that really mean? Who decides if it was real or just an excuse? Today, we break down probable cause under U.S. law, using real court cases, real-life examples, and constitutional principles that affect every American. If you want to understand your rights during police encounters, arrests, and searches, subscribe to this channel. Knowing the law can protect your freedom. Why probable cause matters. Probable cause is not just legal language, it is the gateway to government power. Without probable cause, an arrest can be illegal, a search can be unconstitutional, evidence can be thrown out. Entire cases can collapse. Thousands of criminal cases in the U.S. are dismissed each year, not because the defendant was innocent, but because probable cause was missing. Probable cause is the line between lawful authority and unconstitutional force, and that line matters. Probable cause comes directly from the Fourth Amendment of the U.S. Constitution. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." This amendment was written because the founders feared unchecked government power. British authorities used random searches, arbitrary arrests, general warrants. The Constitution responded with a rule. The government must justify its actions with probable cause. Probable cause does not mean certainty. It does not mean proof beyond a reasonable doubt. In simple terms, probable cause means reasonable belief, based on facts, that a crime has been committed or evidence will be found. Key points. It must be based on facts, not guesses. It must be reasonable, not emotional. It is judged objectively, not by officer feelings. Probable cause sits between suspicion and proof. This is one of the most misunderstood areas of U.S. law. Reasonable suspicion. Lower standard allows temporary detention. Example, Terry stop, probable cause. Higher standard allows arrest and search, requires concrete facts. Example, nervous behavior, suspicion, smell of drugs plus visible contraband, probable cause. This distinction determines whether police can detain or arrest. Supreme Court case, Terry v. Ohio, 1968. This case created the modern stop and frisk doctrine. Police officer observed men pacing in suspected robbery. The officer stopped and frisked them. The Supreme Court ruled, brief detention requires reasonable suspicion. Limited frisk allowed for officer safety. No probable cause required for the stop. This case shows, probable cause is not always required, but arrest still needs it. Illinois v. Gates, 1983. This case changed how courts evaluate probable cause. Police received an anonymous tip about drug trafficking. The tip alone was weak, but police corroborated details. Travel plans, addresses, behavior patterns. The Supreme Court ruled, probable cause is determined by the totality of the circumstances. No rigid checklist. No single factor decides the case. Maryland v. Pringle, 2003. Police stopped a car. Found drugs accessible to all passengers. No one admitted ownership. The court ruled, probable cause existed to arrest all occupants. Shared control can create shared responsibility. This case shows, probable cause can apply to groups, not just individuals. Maryland v. Pringle, 2003. Police stopped a car. Found drugs accessible to all passengers. No one admitted ownership. The court ruled probable cause existed to arrest all occupants. Shared control can create shared responsibility. This case shows probable cause can apply to groups, not just individuals. Searches usually require a warrant supported by probable cause, but there are exceptions. Consent searches, plain view doctrine, search incident to arrest automobile exception. Each exception still relies on probable cause. Judges evaluate probable cause after the fact. They look at police reports, body cam footage, officer credibility, objective facts. If probable cause fails, evidence may be excluded, charges may be dismissed. This is called the exclusionary rule. If an illegal arrest leads to evidence, that evidence may be excluded. Example: illegal stop, illegal search. Discovered evidence, courts may suppress everything that followed the violation. This doctrine protects constitutional rights. Common myths about probable cause. Police always need a warrant. If arrested, probable cause must exist. Probable cause means guilt. None of these are true. Probable cause is a legal threshold, not a verdict. What you should do during police encounters. Stay calm. Ask, "Am I being detained?" Do not consent to. Remain silent. Ask for a lawyer if arrested. Your words can create evidence. Silence cannot. Probable cause is not anti-police. It is pro-constitution. It protects innocent people, legitimate investigations, public trust. If this video helped you understand your rights, like this video, subscribe for more U.S. constitutional law explained, share it with someone who needs to know their rights. Because freedom begins with knowledge, and the Constitution depends on it.